So I'm sure that many people, perhaps even some of you here today, might think the title of the talk is a bit of an exaggeration. Religious freedom under fire. Oh, did I turn the microphone off? How's that?
Is it on? Yeah. No, it's on.
Perfect.
There we go. So, religious freedom under fire. Isn't that a bit of an exaggeration, right? I mean, yes, the Department of Health and Human Services issued a mandate that will force employers to provide insurance coverage for contraception, sterilization, and abortion-inducing drugs. And yes, the Catholic Church teaches that facilitating access to these products and services is wrong. But still, aren't the bishops crying wolf here, trying to make a mountain out of a molehill? Of course, I wouldn't be standing here today unless I thought the answer to that question was no. The threats to religious freedom in our nation today are real, and they're serious. And things will get worse unless we make our voices heard. The HHS mandate is just one example of a larger, disturbing pattern of government disregard for this fundamental right. What is most worrisome is not so much that laws are being passed which burden the free exercise of religion, but the callousness with which this is being done. Kathleen Sebelius, the Secretary of the Department of Health and Human Services, for example, admitted that she never seriously considered whether the contraception and abortion drug mandate would run afoul of the First Amendment. Indeed, when she was questioned about this, she displayed an appalling ignorance of the subject. Obviously, the administration was aware that many people have religious and moral objections to these services. That's why a religious exemption was included, as is common for laws of this sort. But what is unprecedented about the HHS mandate is that the exemption is the narrowest ever in the history of federal law. The definition of religious organization in the exemption is one that tries to make religion a completely insular, private affair. Only religious organizations that primarily employ and serve those of their own faith, and that have as their primary purpose the inculcation of religious belief, are religious enough to qualify for an exemption from the HHS mandate. On the government's definition, Mother Teresa's nuns don't qualify for an exemption because their ministry serves those in need, regardless of religion. The same is true of thousands of Catholic charities, hospitals, schools, and other organizations across the country. As stated in the complaint filed by the Archdiocese of New York, to qualify for the exemption, Catholic organizations would have to stop asking, "Are you hungry?" and ask instead, "Are you Catholic?" before extending services. By choosing this extremely narrow definition of a religious organization, and I say it must have been a conscious choice because it's a radical departure from precedent in federal law, the government effectively sends the message that the only sort of religious activity that it will favor and protect is private worship. It effectively denies the fact that practice of religion can't be limited to one's participation in an occasional worship service, but that genuine religious practice necessarily has an impact on one's broader social, economic, political activity. In other words, the mandate's narrow definition of religion sends the message that the government will protect freedom of worship, but not freedom of religion, understood as the broader freedom to live in accordance with one's beliefs. A related example of callously putting the sexual liberation agenda ahead of religious freedom and the real needs of the most vulnerable in our society is the government's decision to defund the Catholic Migration and Refugee Services, which until this past fall has been a leading provider of aid to human trafficking victims across the country. A November 1st front page story in the Washington Post revealed that the decision to direct funding away from the Bishops' Conference was made by political appointees at, surprise, surprise, the Department of Health and Human Services. Does anyone smell political retaliation for the Bishop's opposition to the HHS mandate here? I wonder. The decision was made despite the fact that staff members in the department had recommended the Bishop's service receive the grant, based on scores by an independent review board. Instead, grants were given to two other groups who had scored so low that they didn't even make the cutoff when they were evaluated by the review board. Why? Because Catholic Migration and Refugee Services won't provide or refer for contraception or abortion. And the ones who suffer from this decision are, of course, the victims of human trafficking, who lose the best qualified provider of aid. In fact, because the two low-scoring groups weren't ready to roll on time, hundreds of victims and their families were left without services. And it's just the same. The people who will suffer if the HHS mandate survives are the sick and the homeless and the hungry that Catholic charities won't be able to serve when the government's crippling fines put them out of business or force them to cut back their operations. But the list of government actions against religious freedom doesn't stop there. The disregard for religious freedom and the narrow view of what counts as religious practice is also evident in recent immigration laws in Arizona and Alabama. Last August, soon after Alabama passed the infamous House Bill 56, cracking down on illegal immigrants, a coalition of Catholic bishops and Protestant church leaders sued Republican Governor Robert Bentley. Church leaders alleged that some of the law's provisions, such as those that forbid harboring illegal immigrants, encouraging them to come to Alabama, or transporting them, would make it illegal to exercise fundamental aspects of Christian ministry, like providing immigrants with basic social services, celebrating the sacraments from them, educating them, or giving them a ride to church. And unlike federal immigration laws, these state laws have no exemptions for religious ministers. The U.S. Bishops' Conference also filed an amicus brief in Arizona versus the United States, which was just decided on Monday. The parts of the Arizona law that were dangerous to religious liberty were struck down on unrelated grounds by the Supreme Court, and the same is likely to happen with the Alabama law as well. Nonetheless, what is troubling is that the states would enact these laws and enact them without a religious exemption. This too reflects a limited and narrow view of religious exercise. As an aside, it's also worth noting that the immigration law cases show that religious liberty is not a partisan issue. The church is willing to go to the mat to defend religious freedom, regardless of whether the threats to that freedom come from the right or from the left. One thing that is particularly troubling about the prevalent government attitudes toward religion is that the idea of separation of church and state has shifted from a legitimate desire to keep the government from entangling itself in the internal affairs of religious organizations to a justification for anti-religious secularism, pushing religion out of the public square, making life uniquely difficult for religious individuals and organizations. In the Migration and Refugee Services case I just discussed, for instance, even worse than the HHS's failure to renew the contract is the fact that a Massachusetts federal court actually ruled that it would be unconstitutional for the government to accommodate the conscientious objections of religious organizations by giving them funding to provide services while exempting them from the requirement to offer contraception and abortion. They argued that such an accommodation would be tantamount to government establishment of religion and therefore be in violation of the First Amendment. That, frankly, is a ridiculous and politically motivated opinion that flies in the face of the best precedents in constitutional law and of the common practice of government partnerships with faith-based organizations throughout our nation's history. The bishops have appealed the ruling largely because it sets a dangerous precedent that would threaten the work of Catholic and other faith-based organizations across the country, organizations that cooperate on similar terms with government agencies at all levels. Consider also the recent policy imposed by Illinois state government to force pharmacists to sell emergency contraceptives, i.e. abortion-inducing drugs, including the morning after and week after pills. The aim of the rule was clear from the outset. The governor announced that its purpose was to stop religion from standing in the way of dispensing drugs and to force pharmacies to fill prescriptions without making moral judgments. He announced that pharmacists with religious beliefs about these drugs should find another profession. Two pharmacists, who had each spent more than 25 years building a pharmacy career, decided to sue. Being told to find another profession at midlife because they had the wrong religious beliefs was an unwelcome mandate. At the trial, the state was totally unable to support its rule. The state had no evidence of even a single person who had been unable to get the drugs in question. In fact, the evidence showed that there were many neighboring pharmacies willing to sell the products, which were also available over the internet. Worse, the government admitted that pharmacies could avoid the rule for common sense business reasons, but not for religious reasons. Refusing to sell the drugs because you want to make more money, that's okay. But refusing to sell them because of your religious beliefs, now that's out of the question. Similarly, when the city of Newark issued an order requiring police officers to be clean-shaven, it exempted those who had medical reasons for not shaving. But when two Muslim officers whose faith demands that they wear beards, showed up saying and asking for a religious exemption based on their faith, they were told that no exemption would be given to them. They were forced by the city to choose between their religion and their jobs. Those officers also brought their case to court. Both the pharmacists and the police officers won their cases, but the hostility toward religion exemplified in these regulations is frankly scary. And it's quite similar to what's happening with the HHS mandate. HHS has granted over 1,400 exemptions to its mandate, affecting more than 3 million employees. And it's granted those exemptions to employers ranging from large fast food chains like McDonald's to major labor unions like the Teamsters. It has done so primarily to mitigate the economic damage and loss of employer-sponsored coverage that the new healthcare law threatens. Just like the pharmacy case in Illinois and the police beard case in Newark, the government is more than willing to accommodate you for business reasons or for health reasons. But when your opposition is based on a religious or a moral objection, they won't budge. I could talk all night giving examples of growing disregard for religious freedom and the many threats to free exercise in our nation today. I won't do that because I want to leave time to discuss the positive case for religious freedom on legal, constitutional, and moral grounds. But before I move on to that, no summary of the dangers to religious liberty currently facing our nation would be anywhere near complete without mentioning how the gay marriage movement and the gay rights movement more generally also brings with it a whole host of grave threats to religious freedom.